Thank you, Madam Speaker. The debate today on these three bills, which are to do with sentencing policy in legislation, the debate has expanded to issues around the effectiveness of the overall approach to the government in trying to tackle the terrible problem Jamaica has with violent crime. The truth of the matter is that those of us who live in or who represent constituencies with communities that have high levels of violent crime, our experience tells us that there is an inadequacy of state response to that problem. That's something we experience week in, week out. There was a time, for example, when the Peace Management Initiative was active in the corporate area in Spanish Town, St. Catherine, and so on, and where one could rely on their trained violence interrupters and their process to come into a community and assist in diffusing conflicts that have arisen and which are threatening to spiral into a series of reprisals to try and nip that in the bud, so to speak. They have been totally defunded, and they no longer effectively exist. The Violence Prevention Alliance isn't able to play that role. The police, through the Department of the Police that deals with community policing, from time to time, they will have these, what they call widely publicized public meetings in communities where there have been problems. And they bring in other agencies to be there. Sometimes the fire department is there. Sometimes the local inspector will be there. Member of Parliament may be there, and so on. And the community gets to be present, and questions are asked, and so on. But the reality is that those events really have little impact on the gang violence or the kind of high level of conflict in the community among gunmen. That is a real problem that needs to be addressed. So the comment that says that the state really hasn't effectively addressed these problems yet is a valid point, and I don't think our experience suggests that we can accept the arguments that have been put forward by the other side today that there are adequate and effective remedies being proposed or rolled out by the government in this regard. Indeed, were it so that the state's responses are fulsome and well-designed and adequate, the private sector wouldn't have to be spending hundreds of millions of dollars on Project STAR to try and make a difference in this very area of life in specific communities. And the Project STAR initiative is something that we commend the private sector for, and I'm not criticizing them. We have not at all. In fact, we have participated. I've participated in events that they have put on, and I strongly support their initiative. But the point is that it is because of the failure of the state to play that role in an adequate and effective way that the private sector has to be stepping in to fill that breach. That is the reality. That is the reality. And no amount of howling and so on can undermine the reality of that. So getting more specific to the bill now. The bill seeks to impose higher mandatory minimum sentences for the crime of murder. Higher, substantially higher. Now, there have been for a very long time mandatory minimum sentences for the crime of murder. Our crime of murder recognizes murders in certain circumstances set out in law which attract the potential death penalty, or if it is not imposed, sentence for life, life imprisonment. and other categories of murder where life imprisonment can be imposed or a term of imprisonment for a specific number of years. And where a term of imprisonment is imposed, there is a minimum below which the court cannot go. And it is that which is being increased. And it is being increased very substantially from, I think, 20 years to 50 years in the case of capital murder, and from 15 years as a mandatory minimum to, I believe it's 45 years for non-capital murder. Now, that is a decision that this Parliament is taking, and the majority are in favor of it. As I said before, when I think these bills were first tabled, my position on that is, personally, I do not like mandatory minimum sentencing, because as somebody who is a lawyer by training, I believe that it is important in our system of governance, where we have a separation of powers between the executive, the legislature, and the judiciary. It is important that the judiciary be unfettered in playing their role of adjudicating justice in the particular case before the court. And that is a fundamental role that they play. So we are here in Parliament making law, and when we impose a mandatory minimum sentence, what we're saying is, regardless of what happens in a particular case, if someone is charged for this offense, the judge has to impose a sentence of at least this minimum amount. And that used to be 15 years for non-capital murder. It could be life, and it was often somewhere in between. Now it is going to be, I believe it's 45, the Joint Select Committee says it's a minimum of 45 years or up to life. And for capital murder, a minimum of 50 years or up to life. Then there's the whole issue of parole. Now, parole is not a right. Parole is something that's granted at the discretion of the parole board and cannot be applied for before a certain portion of your sentence has been served. What the legislation also seeks to do is to say that you are not eligible for parole. You can't apply for parole until you've served a much longer period of time, whether it be for capital or non-capital murder. The effect of this is going to be that the prison population, unless crime, the rates of crime in this country substantially change from where they have been, you're going to have a growing prison population because the duration of the sentences is going to be much longer. We already have heavily overcrowded prisons, especially maximum security prisons. Overcrowded prisons. Our prisons are old. The two main prisons that we have, Tower Street Correctional Facility, better known as GP, and St. Catherine District Prison, are both very old facilities. They are they have serious structural problems, and they are heavily overcrowded. And that situation is going to be worsened by these very high, long mandatory minimum sentences. It also has the effect, apart from the justice side of it, which I've expressed my concern about, which is that it takes away the ability of the judge to look at the facts of the particular case, the circumstances of the case, and impose a sentence that that judge feels is appropriate. That is being, to some extent, curtailed and restricted because there's a floor imposed by Parliament below which the judge cannot go. And it's a very high floor under this legislation. Very high floor. But apart from that, the impact of these very high mandatory minimum sentences on accused persons is that they are going to be, and are already, increasingly reluctant to plead guilty on the basis that the court can award a discount to them that would make sense for them to accept their responsibility for what they did and go and serve time at the discounted amount that the court has imposed. Rather, the incentive is go to trial, take your chances, and depending on how serious a criminal it is, there are other problems in terms of obstruction of justice, which the system has to contend with, where people are going to trial, interference with witnesses, etc., etc. So there are real downside risks for Parliament to be imposing a regime of very high mandatory minimum sentences. We've done it for firearms, and we've seen already in the court system what is happening in terms of the buildup of cases there, in the gun court and circuit courts. And we are now doing it for murder. So these are some of the policy decisions that the government has taken, which have, I think, significant downside risks that we ought to really reflect on in making these decisions. I'm going to turn to the actual provisions in the bill, because I must say I have some concerns. In the amendment to the Child Care and Protection Act, the bill that amends the Child Care and Protection Act seeks to repeal Section 78 of the existing Act and put a new Section 78 in place. And that new Section 78, subsection 3A1, in relation to a capital offense, says that a person who is an adult at sentencing, but who was a child at the time that the offense was committed, is subject to a penalty of 50 years imprisonment. That's the minimum. And the court may specify that the child is not eligible for parole before serving 20 years. So what this does is that it treats a person who offended when they were a child as subject to the same minimum penalty of 50 years imprisonment as a person who committed that offense as an adult. Now, this runs against what is now, I think, internationally accepted policy, that children, when they come into conflict with the law, are to be treated by the court system in a more sympathetic way than how adults are. And the reason for that, of course, is because the kind of issues that children and adolescents in particular are grappling with, and the bad choices that children make because their cognitive skills are not fully developed until they're adults, means that imposing very harsh mandatory minimum sentences is unfair and unwise as a response to how you deal with a child. The new section 78(3)(a)(3) applies to an offender who is a child who has attained the age of 14 years. And it says that that child who has achieved or attained the age of 14 years is subject to, and commits a murder, is subject to a minimum penalty of 50 years imprisonment. And the court may specify that the child is not eligible for parole before serving 20 years. So, it's applying the same regime to a child who is before the court and being sentenced, who is between the ages of 14 and 17 years old, and who may have committed that offense when they were under 14 years. It says, read the provision. It says that when they are before the court as a child who has attained the age of 14, this is a regime that should apply to them. But when they committed the offense, they may have been under the age of 14. That is what it says. That is what it says. Look at it. Now, it may be that there's an ambiguity in the wording of the provision, but it can be read in that way. And I think that's a problem. So the new section 78(3)(a)(2) applies where the offense is capital murder and the offender is under the age of 14. So this is another limb of this now, where the offender is under the age of 14. And I assume that means at the time they're being sentenced. On the other hand, The new section 78.4 applies where the child under the age of 14 commits an offense specified in the fourth schedule. But the fourth schedule includes murder. So you have two parallel tracks dealing with children who are under 14 when they commit murder. You have one under 78.4 and you have one under 78.3a Roman 2. How those two operate at the same time is unclear to me. And I think that's problematic. The new section 78.5 applies where a child of 14 or more years is convicted of non-capital murder. And it says that a child is subject to a minimum penalty of 30 years imprisonment. And the court may specify that the child is not eligible for parole before serving 15 years. Again, this can be read as applying even if the child who is being sentenced was less than 14 years when the offense was committed, because it's speaking in the present tense to the child before the court who is being sentenced and has attained 14 or more years. But what about their age when they committed the offense? That must be brought into account. So in my view, these provisions in the new section 78 of the Child Care and Protection Act, as amended by this bill, are arguably incompatible with the right of every child to such measures of protection as are required by virtue of the status of being a minor or as part of the family, society, and state, which section 13(3)(k) of the Constitution guarantees, and is therefore arguably unconstitutional. I'm concerned that the new section 78 violates the Constitution, and I'm saying it here because we are sworn to uphold and defend the Constitution, and I do not like to pass legislation which may be unconstitutional. And our children are given rights under the Constitution to measures of protection as are required by virtue of being a minor. Furthermore, to impose these long mandatory minimum sentences on persons who offend when they are children, and possibly even offend when they are less than 14 years old, is really excessive. 50 years is a very, very long time. 30 years for non-capital murder for a child offender. And it is not in keeping with the spirit and intent of the Child Care and Protection Act. The Child Care and Protection Act was really there to ensure that children are appropriately dealt with when they come into conflict with the law and how the justice system deals with them. And this, I think, is really inconsistent with the spirit and intent of the Child Care and Protection Act, and indeed with the UN Convention on the Rights of the Child. And UNICEF, who is one of our international development partners, specializing, of course, in children, matters related to children, have written of their tremendous concern with this aspect of the legislation. So I'm really asking the Minister of Justice to look again at Section 78 and the amendments, the new Section 78 that this is seeking to impose. I am not aware that there is a sense that persons who commit offenses as children are being sentenced in too lenient a way. I've not heard anybody say that before. I've seen no evidence to suggest it. So I'm really not sure what's behind this. But we're really bringing in some extreme provisions here in relation to how we deal with children who have fallen afoul of the law in a very, they've fallen afoul of the law in a very serious way. And the law must respond appropriately. But mandatory minimum sentencing for children doesn't allow the court to look at the circumstances of that child, look at the circumstances in which the offense was committed, and to fashion an appropriate penalty and supporting regime to enable that child to hopefully be rehabilitated, which is really what ought to happen If you're sentenced for 50 years minimum, what chance of rehabilitation is there? You know, it's... The other point I want to make, Minister, Madam Speaker, relates to the amendment to the Criminal Justice Administration Act. And it's dealing with the regime of discounts that are available if you plead guilty. And where somebody is pleading guilty to an offense which would attract a life sentence for the purpose of working out what the discount would be and what the sentence should be that is imposed, you have to deem that offense to be subject to a certain number of years. And what the legislation is saying here in the new 42F as amended is 50 years. 50. And I'm glad you said that, Minister, because my recommendation is that should be 45 years. And let me tell you why. Because the effect of it, if you plead guilty at the earliest opportunity that you can, which is what we want to encourage people to do if they're guilty, the 1/3 discount that is available would take you to, if it's a 45-year deemed thing, would take you to 30 years, which is the minimum sentence for non-capital murder. So it would be a coherent system. If it's at 50, a 1/3 of 50 is actually higher than the minimum. So you're incentivizing them to go to trial rather than incentivizing them to plead guilty. So if you put the deemed number of years that's applicable or is treated as being equivalent to a life sentence at 45 rather than 50, you have a coherent system.
Assist the leader of the opposition and colleagues. I'm not closing today, but I want to just we have not in this legislation excluded the plea bargaining act. And one of the good things about high sentence, which I will explain when I close, it might encourage most of them to plead guilty, which is what happened in the United States. You're with me? In other words, we may not be imposing the criminal administration that, discount. But once they plead guilty, they're in a position to engage in plea bargaining. So it could be in the sentence once it is agreed with the judge.
Thank you, Minister. And I understand that point. I'm just simply saying, since you are amending Section 42F, if you chose 45 years rather than 50, the effect of it would be that the incentive would still be to plead guilty rather than to take a chance at trial. Well, those provisions are still going to be in the law, so we may as well make them coherent. So, Madam Speaker, I have real concerns about the treatment of Section 78 of the Child Care and Protection Act. I understand the desire in sentencing persons who commit offenses as adults, especially the offense of murder, capital and non-capital, that the government wants to send a signal by imposing much higher mandatory minimum sentences than existed before. I understand that sentiment. The hope is that it will have a deterrent effect. That remains to be seen. I want to bring to Parliament's attention the downside risks of that approach, which are much heavier problems of overcrowding in the prisons, greater pressure on the prison population. Chances are that there will be greater burdens of courts of cases in the criminal justice system, because persons are facing high mandatory minimum sentences and therefore are less inclined to plead guilty and more inclined to take their chances with trial in an environment where we know that witness intimidation and worse is a real problem, and even jury interference is a problem. So we're putting much greater stresses on the system, the criminal justice system, both in trial process and in the correctional facilities when we take this approach. And I wanted to mention it in Parliament because I mentioned it in the context of the firearms legislation, only to hear from the Minister of National Security, I think in December, that amendments are being brought, which we haven't seen yet, because of the very issues I raised then. And the other thing I wanted to put on record was my own concern about an approach, not so much in the context of murder, because we've always had mandatory minimum sentences, although the levels are being doubled or thereabouts. But we've seen it in the context of firearms. I don't know what else the government is going to come with. Essentially, we're seeing a trend of taking away of judicial discretion over sentencing and giving Parliament a say rather than the judges a say. And that is not the way our system is supposed to operate. And I'm not aware of any evidence that suggests that our judges are not sentencing appropriately. They can sentence up to life, and they often give very heavy sentences. So the claim is being made, but the Prime Minister didn't have the data on the sentencing patterns for those children. He had data on how many children had been charged between 2019 and 2022, but the sentencing aspect of it, we didn't have that data. So I'm just saying that from my perspective, this is a trend that I'm seeing, and it is a trend which goes against the normal, well-established principles of separation of powers and the very important role that judges have to play, which is to ensure that they do justice in the case before them. The victims are there, and the victims and the families of the victims must have a say and must be able to, and they are able to give a statement so that the court has their views to take into account. But the range of circumstances in which people offend varies widely. A former criminal lawyer, once upon a time a distinguished criminal lawyer before he started to do all this conveyancing and so on. You know that, Minister. You know that. You know, it's a vicious serial killer is at one end. And then you have at the other end a youngster who gets into bad company and has no prior record and gets into a situation and does something stupid, and somebody is killed by it. And you can't treat them in the same. You can't, because they're not the same circumstances. One can be rehabilitated, and even forgiveness, you may not forget, but forgiveness is an important part of the healing of victims and their families as well. And they want to see an appropriate sentence, but the consciousness of our people can be elevated to the level where people get closure from having seen the justice done, and justice includes a proportionate response to what took place. Proportionality is vital. So, Madam Speaker, those are my submissions. I hope that the Minister will have another look at the new Section 78 very carefully, in the context of the right of the child under the Constitution that I mentioned here, and the international treatment and requirements of the UN Convention on the Rights of the Child that Jamaica is a signatory to, and which indeed led to the Child Care and Protection Act being enacted. I wouldn't want to see us go down a route that we later have to backtrack on and wheel and come again. I thank you, Madam Speaker.
Closing out for now, this is One Avenue News. Avenue for your news, views, reviews, and much more. New spot on the block where we chat. Looking forward to meet you in the comment section. So flick the subscription button, turn on notification bell. Let's journey together. And please remember, we need solution, not confusion. United we win, my people. Art of love.